Good morning.
Good morning, everyone.
Good morning, sir.
Good morning. So because of some urgent work, economics lecture could not be conducted as per the schedule. So we will be having our legal aspects of business in today's 7 a.m. session. Yes, I hope that you can see my screen.
Yes, sir.
Okay, thank you. So during our last lecture, we had discussed about the rights of the agent. Yes, this we had discussed, rights of agent towards his principal. Now we will be discussing what are the duties of an agent towards his principal. Now we all are uh, aware that what is the meaning of an agent and principal. So agent is a person who is appointed by the principal to carry out his business activities. Principal is the person who appoints the agent. So person who appoints the agent is called as principal, and the person who is working for the principal is called as agent. So in the last lecture, we had discussed what are the rights of the agent. Now we will be discussing the responsibilities or duties of the agent. Then we will talk about the rights and duties of principal towards his agent. So it is vice versa. Both the principal as well as agents are having certain rights as per the law, as well as they have to carry out certain responsibilities towards each other. So rights of agent we had already discussed. Now we will talk about what are the duties of an agent towards his principal. So first one, and these duties and rights are very simple and they are self-explanatory. So we will just have a quick go through on these. So duties of an agent towards his principal. First is to conduct principal's business according to his instructions. Very simple. Whatever instructions the principal has given to the agent to carry out his business activity, those instructions are to be followed by the agent. These are the simple responsibility. This is the simple responsibility of the agent. For whatever purpose the person has been appointed, the person has to complete that purpose. The person has to follow that guidelines, rules, or instructions of the principal. Next one, duty on the termination of agency by his principal's death or insanity. Insanity, we all know what is the meaning of insanity. We have discussed in our capacity of party. On the death or the principal becoming insane. In such cases, he has to render all the accounts of the agency to the legal hire of the deceased principal. So the principal who is now no more, what is the responsibility of the agent is that whatever business he is carrying out on behalf of his principal, he has to give the details to the legal hires of the principal. That is his duty in case the principal is no more, or he has now become insane. Next one, to conduct work with reasonable care, skill, and diligence. Again, very simple. It is self-explanatory. How he has to perform his work? He has to conduct his work or her work with reasonable care, skill, and diligence. Now, suppose perishable products are to be transported, and the principal has given this responsibility to the agent, then he has to take a reasonable care that these perishable products are protected well against sunlight or against the other eventualities. So this is called as that he has to conduct the business with reasonable care. That okay, if the vegetables are to be carried from one place to another place, how these vegetables are to be carried? If it is carried in a truck, then it should be properly loaded in crates. Then the crate should be covered with a piece of cloth so that it is not directly in contact with the sunlight, and it can save the vegetables from getting spoiled quickly. Now, if the agent knows that he is transporting the fresh vegetable from one place to another place, and still, if he is not taking care in covering those crates of fresh vegetables, and these crates are open and they are very much open to the sunlight, and because of that, it may get spoiled. Still, if he is not covering, then we can say that he is not following his responsibility. Why? Because he is not taking due care, which is required to carry out his business of activity. So that is called as to conduct work with reasonable care, skill, and diligence. Next one, to render accounts properly to the principal. Very simple. When he is working as a connecting link between the principal and the third party, whatever amount he is collecting from the third party, he should render that amount properly to the principal, because he is just a connecting link. He will be collecting the amount from the third party and transferring that amount to the principal. He cannot keep that amount with himself. So that is to render accounts properly to his principal. To communicate with the principal in case of difficulty. So if he is having any difficulty in carrying out the activity of his business, then first thing he should do is that he should try to get in touch with the principal and update the principal about the problem he is facing. Let the principal give the solution of that particular problem. On his own, without contacting the principal, he cannot take a decision. Why he cannot take a decision? Because he is not principal, he is agent. He is to follow the instruction of the principal. Only in case of emergency, when the principal is not reachable, then in the good faith of principal, if he takes decision, then it is acceptable. Otherwise, it is not. Not to deal on his own account in the business of agency. Again, as he is just a connecting link between the third party and the principal, he cannot enter into an agreement on his behalf. He has to enter the agreement on the behalf of his principal. So he cannot say, suppose a transaction is to take place, transaction of 5 lakh, 10 lakh, or maybe more. Then what he is supposed to do? He is supposed to share the account details of his principal. Here he cannot share his personal details. Okay, these are the details of my principal. You deposit 10 lakh rupees in this particular account. If it is done, then it is not the responsibility of the agent. What agent is supposed to do? He has to share the account details of the principal. Am I audible to all?
Yes, sir.
Okay, thank you. Now the next one, not to earn or make secret profit from the agency. Again, very simple. Whatever incentive, salary, commission, brokerage has been fixed between the principal and the agent, the agent is supposed to take that only. He cannot add or he cannot take a secret profit from the agency. If he is taking secret profit from the agency, then he is not following his responsibilities. Next one, not to use information obtained in the course of agency business against principal. Now, if the principal is carrying out a business and during that conduct of business, if some secret information the agent gets to know, it is expected that he should not divulge that information or share that information with the competitors of the principal. Now suppose principal has filled a tender for construction of say road, and in that tender he has quoted a particular price, that for a kilometer of road this will be the price. Now this tender is with the agent and agent is aware of the quoted price also. Agent is given the responsibility that agent has to submit that envelope containing the quotation of the principal to the PWD official or office. Now here, if the agent shares this information with the competitor, the other person also who is interested in knowing what is the quotation of his principal, if the agent shares this information to the competitor, then again it is the breach of responsibility. We can say that agent is not following the responsibility, and here action can be taken against the agent by the principal. Next one, to pay sum received for the principal. Very simple. Whatever amount, whatever sum the agent receives on behalf of the principal, it is to be given to the principal. Simple. Liability in respect of damages and misconduct. Now, whether the agent is responsible in case of damages. So here we have to take into consideration that if after taking due care also, if certain damages has taken place, then agent is not responsible. That agent was taking the truck full of the fresh vegetables from one place to another on the instructions of the principal. While in transit, the truck met with an accident and it was not the fault of the agent. If any loss happens because of that accident, which is not because of the conduct of the agent, here agent is not liable to pay compensation or damages to the principal. But agent was under the influence of drinks, and as he was drunk and he was driving the vehicle, the vehicle met with an accident and there was loss to the principal. Here in this case, yes, the agent is liable to pay the damages to the principal. So we have to check whether the agent is doing it intentionally or not intentionally. If he is drunk and still he is driving, that means he is doing it intentionally, he is liable to pay damages. He was not drunk, he was driving properly along his side, speed limit was as per the rule, and still he met with an accident because of the fault of the other person, then here he is not liable to pay the damages. So that we have to discuss. We have to take into consideration whether the person is every time the agent is not liable, when he is liable and when he is not liable. For misconduct, yes, every time the person is liable, the agent is liable. Misconduct means specific instructions have been given by the principal to the agent to carry out his business on a particular manner. And after knowing the instructions, still if he is overruling, agent is overruling those instructions, he is not following those instructions, then we can say that he is involved in misconduct. And every time if the agent is involved in misconduct and there is some loss to the principal, the agent has to compensate that loss of his principal. Now the opposite we will be talking about. Now till now we have discussed the rights and responsibilities of agent. Now we will talk about the rights and responsibilities of principal. First, right to demand accounts. Very simple. As he has as the principal has appointed the agent, he has every right that he can anytime demand the accounts. That okay, I had told you to collect the money from that particular party. What is the current status? Have you collected? Have you transferred the amount to my account? So these type of questions every time he can ask because he is the appointing authority. Next, right to repudiate the contract when the agent deals in the business of agency on his own account. The meaning of repudiate is to revoke, is to cancel. So there is a right available to the principal that anytime he can repudiate or revoke or cancel the contract of agency, the contract of his agent. When he can cancel anytime the contract, it is also mentioned. When he comes to know that the agent is dealing not on his account but his own account, not on the account of the principal but on his own account of the agent. When the principal comes to know about this information, there the principal has every right that he can revoke, he can cancel the rights of the or the contract of agent. Next one, right to benefit gained by the agent dealing on his own account in the business of agency. When the principal comes to know that agent has entered into a particular agreement and he has collected that amount on his personal number or personal account, he can demand from the agent that transfer that amount to my account. So that is his right. Right to recover damages. So that we had just discussed that when the principal can recover damages from the agent and when he cannot. Next one, right to refuse remuneration to the agent when he is guilty of misconduct. Whatever remuneration is due, whatever brokerage or whatever commission is due to be paid to the agent by the principal can stop that salary, that commission, that brokerage, if the agent is not following his instructions, if the agent is involved in misconduct. Next one, right to revoke agent's authority, that we have already discussed, that when the agent's authority can be cancelled, can be revoked. Last one, right to ratify or agents act. Now ratify and the other one is disown. Now we are now very much clear that agent is supposed to carry out the business activity on the instructions of his principal. Now ratification and disowning, it comes into existence when the agent moves out of his own authority. The agent enters into a contract on behalf of his principal, but without the instructions of his principal. Here, the principal is having two options. If the principal feels that although the agent has exceeded his authority, although without taking his permission, the agent has entered into a contract on the principal's behalf with the third party. If the principal feels that this particular contract, this particular agreement, which is carried out by the agent without taking his instructions, is profitable to him, then he can ratify that past act of the principal, and that is called as ratification of the contract. Next option available to the principal is disown that act. As the agent has entered into the contract with the third party without the instructions of the principal, the easiest option available to the principal is that disown that act. Disown that act, that he is not going to ratify that, accept that agreement which is conducted between the third party and his agent. So ratification can be done, and cancellation or disowning can also be done, and that is the right of the principal. Next one, to pay remuneration and dues to the agent. Again, very simple. Whatever remuneration, whatever dues which were promised by the principal to his agent, that is to be paid to the agent. That is, now we are talking about the duties of the principal. So he has to pay the remuneration or dues to his agent. Next, to indemnify the agent against the consequences of all legal or lawful acts. Legal acts. If the third party has filed a case against the agent for, say, breach of contract or for damages or for any loss in the court of law, as the agent was working on behalf of the principal, it is the responsibility of the principal to bear all the loss or all the cost that is to be done in filing the case or in say fighting that particular case against the agent, because agent is just a connecting link. He is working on behalf, and still if the third party takes the agent to the court of law without taking the principal to the court of law, then it is the responsibility of the principal to protect the agent's interest in the court of law. He has to pay all the charges to maintain that particular case in the court of law. Next, to compensate agent for injury cost. While carrying out the business activity of the agency, if the agent meets with an accident, then it is the responsibility of the principal to bear that particular cost. Next one, with entered by the agent with the third parties, that we have already discussed, that there are two things. One, the principal can ratify the contract, and the other thing is the principal can disown or cancel the contract. Liability, when he induces the third party to believe that agent's unauthorized acts were authorized. Now here a bit of, say, confusion we can say is there. Liability when he induces the third party. Who induces the third party? Principal is inducing. Inducing means making believe the third party that the unauthorized acts of the agent are authorized by him. Now, if say third party, principal and the agent all are present at the time of the signing of contract. Now, if the agent is exceeding his authority and the principal who is standing next to the agent, he is aware that the agent is exceeding his authority, and still if he keeps quiet, the principal keeps quiet, and because the principal is keeping quiet, the third party believes that whatever information, even if the excessive information, wrong information is being shared by the agent to the third party while entering into a contract, the third party believes that yes, it is true, because his principal is not interfering. The principal is keeping quiet means he is sanctioning that act of the agent. Now, if such thing is there, then the principal is liable to pay the damages to the third party. Here, the principal cannot claim that he is not involved in this act or he has not signed the contract, because here, if by keeping quiet he is aware that the agent is exceeding his authority, and still if he is not letting the third party know that no, this is not the case, agent is exceeding his authority, I am his principal and I know that his authority is limited to this only, then he is liable. Last one, liability on account of agent's misrepresentation and fraud. Now, for misrepresentation and for fraud, who is liable? Now, we all know the difference between misrepresentation and fraud. Misrepresentation is sharing wrong information without proper knowledge, or there is no intention of a person to share wrong information, but as the person who is sharing wrong information believes that whatever information he is sharing is correct. So because of some mistake, the person is sharing wrong information. So this is misrepresentation. fraud is always intentional. So in case of fraud, the principal is liable to pay the damages. In case of misrepresentation, if it is proved that there was no such intention to deceive, then he is not liable. Now we will talk about how the agency is created. So creation of agency, agency by express agreement. Am I audible to all?
Yes, sir.
Yes, sir.
Okay. Yes. So agency by express agreement, very simple. We all are aware of it. If a contract of agency is entered between the principal and the agent in written form or in oral form, it is called as agency by express agreement. Now, agency by implied agreement, it is same as we had discussed when we were discussing the types of contract and when we had discussed the difference between express contract and implied contract. So, a agency which is created by the conduct or action of the person is called as agency by implied agreement. So express means either in oral form or written form signed between the principal and the agent. Implied means no oral, no written, but it is acceptable. Why it is acceptable? Because of the conduct of the principal and the agent, it has came into the existence and it is acceptable in the court of law also if it is proved with the help of proper evidences. Now, under creation of agency or agency by implied agreement, there are two major types of agencies. One is called as agency by estoppel, and the other one is called as agency by necessity. Agency by estoppel means, the meaning of estoppel is to make the other person believe. Agency by estoppel means that when an agent makes the third party believe that the business activity which he is carrying out is not his own, he is carrying out the business activity on behalf of his principal, then it is called as agency by estoppel. Now, for example, the principal owns a small mall in Mumbai, but the principal stays in Pune. Now, to carry out that mall, the activity of that mall, the principal has appointed an agent. Now, this agent always, whenever some products or some items fall short in the mall, he goes to a certain wholesaler and he collects those items on the credit of his principal. And when after 1 month, after 2 months, after 15 days, when the principal visits his mall, whatever products or items has been purchased on the credit of the principal goes to the wholesaler and he clears those bills. So here there is no contract between the third party, that is the wholesaler, and the principal. But still, because of the act that after every 15 days or after every month, the principal comes to the place of wholesaler, checks with the wholesaler that how much amount is there, or how much item or products have been purchased on his credit or on his account by the agent, and he clears that bill. It happens one time, it happens second time. So it will make the wholesaler believe that although there is no written agreement between the wholesaler and the creditor, whatever item the agent is collecting on behalf of his principal for the principal small is officially as per the instructions of the principal. So that is called as creation of agency by estoppel. It is always implied agency. It is not a express agency. When it will become express agency? When there is a written contract or oral contract between the principal and the third party, between the principal and the agent. If there is no contract, that still the principal is approving the actions or acts of the agent, then it makes the third party believe that yes, there is a agency, and that is called as agency by estoppel. Although it is not in written form, it is not in oral form, still it is treated as a valid contract in the eyes of law. If because of breach of contract any of the party goes to the law, goes to the court, this case can be entertained in the court of law. Only thing required is proper evidences should be produced in the court to prove that there is breach of contract. Next one, agency by necessity. Now the word necessity, जरूरत के समय, जब बहुत जरूरत है तब, अगर because of some emergency, because of some necessity, that if this is not there, then there can be a huge loss. If such is the situation, without any oral or written form also, there can be a contract, and that contract will be implied contract, and that contract will be termed as the agency by necessity. बहुत इमरजेंसी थी, बहुत जरूरत थी, इसीलिए वो एजेंसी क्रिएट हुई, ऐसा कोर्ट मानेगा in case if a case is filed. So that is called as agency by necessity. Now under agency of by necessity, there are three different situations where we can say that there can be a agency by necessity. First one, when the agent exceeds his authority in case of emergency. Second, when a person is entrusted by another's property. And the third one is husband and wife. Now, when an agent exceeds his authority in emergency, that we had discussed, that if because of some emergency situation, and when the principal is not reachable, if some decision is taken in good faith by the agent, that decisions are to be accepted by the principal later on. It has to be ratified by the principal, and that is called as creation of agency by necessity under when an agent exceeds his authority in emergency, that we had discussed. Now the next one, when a person is entrusted by another's property. Entrusted by another's property. One person has given, or we can say trusted somebody that this is my property, please keep it at your place for some days, and after some days I'll collect that property from you. So in this case, even if there is no contract, still it can be, if because of the situation it is in the court of law, it will be trusted as, or it will be taken as the implied agency under agency by necessity. Now here, for example, two neighbors are there. One neighbor who owns two dogs. Now this neighbor who owns two dogs has to go to another place because of some emergency situation. One of his relative is not well and he has to go to that relative's place. His neighbor, Mr. A's neighbor, Mr. B is there, and Mr. A and Mr. B, that both the neighbors, they enjoy good terms with each other. So Mr. A, who wants to go to another place the next day only, he cannot take both the dogs with him to his relative's place. So he requested Mr. B, his neighbor, that please keep my dogs at your place for 3 days. Once I am back, I'll collect the dogs from you. So this is entrusting of property. He is trusting his neighbor that the neighbor will take care of his property, and the neighbor also readies. Okay, no problem. You go, I'll take care of your two dogs. Now, for a period of 3 days, the neighbor invested some amount in the feed of the dog. Dogs were hungry, so he went to the market. He got pedigree for the dog and biscuits for the dog, or other food items for the dogs. Now, as the owner was not there with the dogs, one of the dogs felt he was not well. And as the dog was not well, the neighbor called the doctor also. The doctor came, he charged his fees, he prescribed some medicines. Again, the neighbor had to pay or invest some amount in that particular thing. Now, what had happened after 3 days, when Mr. A came back and when he went to Mr. B, that okay, I'm now, thank you very much for keeping my dogs for 3 days. Now I want my dogs back. Now here, if Mr. B lets the Mr. A know that okay, no problem, your dogs were there, I took a great care of those dogs, so I have spent, say, 1000 on their feed, and I have also spent 5000 on their medicine and doctor charges, so I want 6000 rupees from you. Now here, it is the responsibility of Mr. A, he has to pay this amount to the neighbor. Here he cannot claim that you should have first called me. Then I should have approved your activity, that whether the doctor is to be called or not. Because of necessity, because of some emergency, as the dog was not well, the neighbor has called the doctor without informing the owner of the dogs, without informing Mr. A. So he has acted in case of emergency, and it was necessary. Out of necessity, he has done that. And when the agent has done out of necessity, then court always accepts it. And if it is, say, if Mr. A refuses to pay 6,000 to Mr. B, no, I will not pay you. And if Mr. B goes to the court of law, although there was no written agreement, although there was no oral agreement between these two neighbors, but still the court will admit the case under the creation of agency by necessity. Why he has called the doctor? Because of that necessary situation, and that is called as necessity. In case when a person entrusts by another's property. And the next one is husband and wife. Now here in India, it is a rule, a unwritten rule, we can say, where it is not a written rule, it's an unwritten rule. Here agent is wife and principal is husband. This is assumed. It is not fixed. It is not written. It is assumed by the court of law. If a case is filed by the husband or wife, the court can decide whether this particular case can be considered as a case of under creation of agency by way of necessity. So for example, there was a case which was filed in the High Court, and the case was that husband was working in another city and wife was staying alone. As wife was not working, she was not earning, she was dependent on the husband. So wife made certain expenses, or she purchased some items for her day-to-day purpose, day-to-day living purpose. And when the husband came to home, at that time the husband refused to pay the third person the due amount, as the wife has taken those items on credit of the husband. That my husband is working in so and so city, he will be coming in next 10 days. As he will come, we will clear all the dues. That was the deal between the wife and the seller. So wife purchased certain items, and the seller also believed that okay, no problem, as the husband is working in some other city and the wife right now is not having money. So he gave her on credit of the husband. When husband came back, the husband refused to pay, and the husband was of the opinion that as I was sharing some. I had shared you some amount. You should have used that amount only. If you were not having any, say, the amount remaining, you should have informed me first. Then I should have ratified your, say, request. And then if you had went to the shopkeeper or seller and then you had purchased those, then only I was responsible. Now I am not responsible because you had not taken my permission. Here, this was the case where the husband refused to clear the dues of the wife. And here, when a case was filed, here the court decided it is the responsibility of the husband to maintain wife, and it is the responsibility of the husband that he has to clear all the dues of the wife. He cannot claim that as the wife has not taken his permission before getting those items on his credit, he is not responsible. Now here, wife has to pay and he is not responsible. He cannot claim that. Although it was claimed by the husband in the court of law that as she has not requested me, as she has not called me, that I'll be purchasing these items on your name, on your credit, so I should not be held responsible. But here the court rejected the appeal of the husband, and the husband was, the ruling was against the husband. It was decided in that ruling that husband will be considered as principal and wife will be considered as agent, and all the acts of wife will be considered as the acts of the principal himself. So that was the case. Here, the court has also decided that only in exceptional case the husband can be relieved of this, and that exceptional case is if the husband categorically, specifically informs that store that if my wife comes to your place for shopping, I should not be held responsible or I will not be paying for her bills. If specifically this is informed, then only the husband is relieved of his responsibility. Otherwise, all the acts of wife are termed as agency by necessity. Here, the husband cannot claim that the cream which was the face cream or face pack which was purchased by my wife cannot be included in things of necessity or necessity things. बहुत जरूरी है फेस पैक, ऐसा नहीं है इसीलिए मैं फेस पैक के पैसे नहीं दूं. तो कोर्ट ने क्लियर किया कि जो भी वाइफ खरीद रही है उसकी रिस्पॉन्सिबिलिटी हस्बैंड की ही है कि हस्बैंड हैज टू पे. ऑल द थिंग्स will be covered under agency by necessity. So that was the ruling. Only thing the court said was that only if the husband specifically gives instructions to a particular seller that please do not give anything on my credit to my wife. अगर ऐसा है तो ही वो बच सकता है. वो भी उसमें भी कंडीशन डाले गए. कंडीशन ऐसा था कि सपोज नेसेसिटी के लिए थिंग्स ले रहे हैं तो तब भी हस्बैंड इज रिस्पॉन्सिबल. उसने लिख के दिया है एक शॉप में कि यहाँ पर अगर आप कुछ भी मेरी वाइफ को उधार देते हैं तो मैं रिस्पॉन्सिबल नहीं हूं, पर वहां पर अगर वाइफ नेसेसिटी आइटम खरीदने के लिए जाती, नेसेसिटी मीन्स जो जरूरत के सामान है, जरूरत का सामान मतलब खाने पीने का सामान, दूध के लिए अगर उधार पे है, कुछ किराना का आइटम अगर उधार पे है, तो इधर हस्बैंड हैज टू पे, हियर ही कैन नॉट क्लेम. हाँ, फेस पैक है और हस्बैंड ने लिख के दिया है और फिर मिल रहा है, तो ही इज नॉट रिस्पॉन्सिबल. सो दिस इज द केस related to husband and wife, and how the court has decided this case, how the court has approved the actions of wife, how the court has in an say unwritten manner, the court has cleared the doubts that in India husband is principal and wife is agent, and wife, whatever acts of wife, these acts are to be ratified by the principal, that is husband. So that is called as creation of agency by necessity. What's the time now?
Two minutes are there, sir.
Okay, so we will complete the remaining 2 points. Agency by operation of law. Agency by operation of law, it is very simple. Agency as per law is agency by operation of law. Last one, agency by ratification. So ratification, that we had discussed when we were discussing about the point related to the rights and liabilities, or rights and duties of the principal towards his agent. That when a principal can ratify the past act of his agent, and when he can disown or cancel that act. So that is called as ratification, agency by ratification. For example, now the principal is involved in the business of real estate. He has appointed an agent who will take care of selling his real estate to the third parties. Now, by selling the estate to the third parties, the agent comes to know that there is a plot and which is to be sold, which the owner is ready to sell for a very say cheap price, and the principal is not available, the principal is not reachable. In good faith, he feels that my principal will be happy if I can purchase this plot on his behalf. That is why the agent enters into the agreement with the third party that yes, my principal is ready to purchase your flat for that cheap price, whatever the price was. Now later on, when the principal was contacted by the agent, and when the agent informed the principal that sir, I had purchased this particular plot because it was coming at a very cheap price. Now here, as earlier it was not sanctioned by the principal. Now principal is having two options. One is approve this action of the agent, and second, reject this action of the agent. If the principal approves this action, okay, very good, you have done a good job, I'm very happy with your job, then we can say this type of agency will be called as agency by ratification. So ratification is done for the past event. He has ratified. Ratified means he has sanctioned. Who has sanctioned? The principal has sanctioned. The एक्शन ऑफ हिज एजेंट. सो एजेंट ने जो प्लॉट खरीदा प्रिंसिपल के नाम पे थर्ड पार्टी से, जो बाद में प्रिंसिपल को पता चला, जैसे ही उसे पता चला कि अरे ये तो बहुत सस्ता प्लॉट मिला है, इसके ऊपर मुझे बहुत प्रॉफिट होगा, और अगर वो उसका एक्शन, उसका एक्ट वो सैंक्शन कर देता है, ओके गो अहेड, कोई प्रॉब्लम नहीं है, मैं वो थर्ड पार्टी को 1 लाख 2 लाख 5 लाख जो भी प्लॉट का पैसा है वो दे दूंगा. दैट मीन्स ही हैज अप्रूव्ड, ही हैज सैंक्शनड the act of the principal. Then we can say that this is called as agency by ratification. So he has sanctioned means he has ratified the act of the agent. And the other option is cancel also, कि ठीक है मेरे से बिना पूछे किया है, मैं रिस्पॉन्सिबल नहीं हूं, मतलब एजेंसी कैंसल. ठीक है. So that is called as agency by ratification. So we will stop here. In next lecture, we will try to complete our first unit and then we will start with the second unit also. Thank you.
Hello, sir.
Yes.
Hello. Sir, I'm having doubt in syllabus. Business research methods, generic core subject is there, which hasn't been started yet. The lectures has not started yet. So
very shortly
when
we will be starting the lectures.
And about MS Excel and cyber security and human rights, 3 subjects are there for generic elective and credit
Okay,
courses.
for for cyber security and human rights, we will be sharing you notes. It is extra credit. So as per university,
Okay.
as per the instructions of university, we need not conduct the lectures for these 2 subjects. So we will be sharing you the study material for these 2 subjects. 25 marks questions will be there, MCQ type of questions will be there. We will be sharing everything with you. On that learning material only 25 questions will be asked and you need to apply for these 25 questions. Now regarding your business research methods, business research methods and MS Excel we will be starting shortly. Now what we are waiting for is, we are waiting for the government instructions, because every day some new instructions come up in the news, that whether the college is going to start from offline or it will remain online. Still nothing is clear. We are waiting for the university instructions. As and when we will be receiving that whether we have to go online, offline, or continue online, we are waiting for those instructions. We will be starting. We are waiting only for those instructions, right? So don't worry, we will take care of these 2 subjects also, MS Excel and business research methods. If the instructions comes very soon, we will be starting. Anything else?
Okay, sir.
Okay, thank you. Anything else?
That much only, sir. Okay.
Thank you. Sure. Thank you everyone.
No, sir. No, sir.